Okay. So I'm representing the European Commission at this event. And to give you context, European Commission is the executive body of the European Union. It's a union of 27 EU member states. And the role of the European Commission is to propose new laws and policies, to monitor their implementation in 27 member states, and to manage EU budget. The Commission also ensures that the EU policies and laws are correctly applied across 27 member states. It negotiates international agreements on behalf of the EU and allocates funding. It also represents the interests of the EU on the global stage and ensures coordinated approach among EU countries. My department has a very complicated name, Directorate General Taxation and Customs Union. In short, it is called DG TAXUD. And this is one of the departments of the European Commission responsible for EU policies in the areas of taxation and customs union. Finally, my unit, TAXUD Unit A4, its official title is Protection of Citizens and Enforcement of Intellectual Property Rights. And the role of my unit is to manage the various legislations that customs enforce at the border in the area of health, safety, environment, and protection of intellectual property rights. And my tasks in particular include relations with third countries in the area of IPR customs enforcement, also negotiation of that particular section of free trade agreements, where I support my colleagues from DigiTrade in negotiations of that chapter. And now let's go to the very gist of my presentation. The EU legal framework for customs enforcement of intellectual property rights. Let's see how we stand vis-à-vis TRIPS agreement. TRIPS is the agreement on trade-related aspects of intellectual property rights. It dates more than 30 years ago. It was first signed in 1994, and it sets out minimum standards for IPR protection. However, its members may decide to go beyond the minimum standards established by TRIPS and establish additional measures. And this is what we do in the EU. We go a little bit beyond what TRIPS requires. We cover areas that are not dealt with by TRIPS, or we add more detail to some provisions where TRIPS does not offer much. And then in the EU, we also turn certain TRIPS flexibilities into obligations. Let's see in detail what our legal framework is. So our basic act is Regulation 608 from the year 2013. It has been in force since January 2014. Right now, actually, we are evaluating the implementation of this regulation as it's already more than 10 years old. To complement this main legal act, we have also Commission implementing regulation, which basically, I will talk about it more in detail later. It basically establishes the format of the application form for customs action. and provides what type of information the right holder has to provide in an application for customs action and how this application has to be filed. As I said, I will talk about this particular implementing regulation more in detail later. So, Regulation 608, what does it do? It empowers customs to detain goods subject to customs supervision, goods that are suspected of infringing an intellectual property right, either conferred by the European Union or national law. It's very important to highlight that it provides only procedural powers for customs. So it sets out conditions and procedures for administrative customs enforcement of intellectual property rights, but all the provisions as to what is considered an infringement of a trademark, design, copyright, etc., this is regulated in IP substantive laws. And the decision if an infringement has taken place is left to the competent national courts in EU member states and to the Court of Justice of the European Union. Which intellectual property rights are covered? I'm sharing with you the full list. As you can see, it's much more extensive than what is foreseen in the TRIPS agreement, which talks only about counterfeit trademarks and pirated copyright. The scope is considerably larger in the EU. This is because we believe that to be really effective in the fight against IPR infringements, we need to cover different types of infringement and different types of intellectual property rights. Further, what is the scope of EU customs action at the border in line with Regulation 608? So customs are empowered to act with regard to all goods under customs supervision. What does it mean, customs supervision? Customs supervision applies to any good brought into the customs territory of the Union. So in practice, it is not limited only to goods arriving at import. EU customs are empowered also to act in other customs situations. For example, when the goods are declared for release, for free circulation, for export or re-export, when the goods are leaving or entering the customs territory of the Union, and when they are placed under a suspensive procedure in a free zone or a free warehouse. So we think it's very important in the fight against IPR infringements to join forces with our partners. So not only to control at import, but also whenever possible to control in other customs situations in order to prevent IPR infringements together. And this is because counterfeiting and piracy, of course, is a global phenomenon, and we need to act jointly. However, of course, as in the case of Indonesia, there are some exceptions to the power of customs. We also do not, our customs are not empowered to act with regard to goods of non-commercial nature contained in travelers' personal luggage. And there are some other exceptions where the regulation does not apply. So how can customs act? First of all, they might act upon an existing application for customs action, what we call in the EU the AFA, which must have been lodged to a competent customs department and granted by customs to the right holder of a given intellectual property right. I'm displaying you the standard form, which exactly is provided by the implementing regulation, which I was referring to before. And I believe that tomorrow my colleague Kenneth will tell you more about how to fill in application for customs action and the importance of providing some information to customs officers to enable them to detect IPR infringing goods. However, one important detail, also in the EU, we do not charge the applicant with any fees to cover administrative costs of application for customs action. Applicants, right holders might be charged fees related to storage or destruction of IPR infringing goods, but for the application as such, we don't charge any fees. Customs might also act ex officio, that is, on their own initiative when they have a suspicion on the basis of reasonable indications that goods under their supervision infringe intellectual property rights. How does it work in practice? Of course, customs might have some information based on risk analysis. They might have information from some other sources of intelligence. They detain goods and they try to identify a right holder. In that case, they notify the right holder, who has only 4 working days to submit in return a simplified application for customs action, allowing customs to act to protect their intellectual property rights in that case. What is very important in the EU for almost a year now is that the application for customs action must be filed electronically. We introduced this obligation in October 2024. And right holders have at their disposal a few trader portals. One of them is IP enforcement portal, EUIPO, which is EU-wide platform. And I think Berenger is going to talk about it more in detail tomorrow. Also, applicants from Germany and Spain have national trader portals through which they might submit AFAs. And the flow of applications is fully electronic, and thus it reduces administrative burden to customs with examining the applications and processing them further. And this is especially important as 27 EU member states and their customs administrations must cooperate. So thanks to the electronic flow of documentation, this is much easier. Now, this part of my presentation is going to be a little bit technical because I would like to explain to you more in detail how actually customs act what are the steps and obligations. So based on Regulation 608, customs act when they have reasonable indications that goods infringe IPR. As I said, it might be based on information provided by the right holder, but also other sources of information, risk analysis, other intelligence might indicate IPR infringement. So based on this, customs detain or suspend the release of goods, as I said, upon an application for customs action or on their own initiative. Subsequently, customs need to notify in the standard procedure both parties, so the right holder and the declarant or the holder of the goods. If requested, customs might provide details on consignor and consignee, for example, and some other information to the right holder in order to, for example, reach out-of-court settlement or actually to start a court action against the infringer and for other reasons. Customs also, when requested, shall give the parties the opportunity to inspect the goods. When the goods are detained, in the notifications, customs share photos of the suspected goods in order for the right holder to assess whether the goods infringe their intellectual property rights. In more complicated cases, sometimes an inspection of the goods is needed, or even samples can be sent to right holders for further analysis. This is, of course, very important in case of more technical intellectual property rights, such as plant varieties, patents, etc. The next part of the procedure is the destruction of the goods. However, it might only take place in the following situations. So in the EU, it's possible to destroy IPR infringing goods without prior administrative or judicial proceedings to formally determine the infringement. If the right holder confirms that their IPR is infringed within a prescribed time limit, and if also the right holder confirms his agreement to destroy the goods, and if the declarant or the holder of the goods confirms their agreement for the goods to be destroyed, if all these conditions are met, then customs might take a decision to destroy the goods. If one of these conditions have not been met, the goods will be released unless the right holder initiates a judicial action to determine whether an IPR has been infringed. In some cases, and in some EU member states, customs apply what we call the dim agreement with regard to the declarant or the holder of the goods, which means that if the declarant or the holder of the goods does not confirm within 10 working days his agreement to destruction, a deemed agreement might apply, and also destruction might take place. Destruction takes always place under customs control and under the responsibility of the right holder. And thanks to this simplified procedure, where court is not involved, we can, let's say, eliminate from the market obvious cases of infringement, smaller consignments or consignments of smaller value, but also, in evident cases, we can proceed faster, because as we know, a judicial procedure might take a considerable time. And of course, for a pair of sneakers or a few t-shirts, we will not, the right holder most likely will not launch a court action, because it's not really interesting for such a small amount. Okay, contrary to Indonesia, our customs are empowered to act with regard to parcels sent by post and courier services. But also a few conditions must be met for this to apply. There is a special simplified procedure for small shipments sent by post and courier. If such a procedure is requested by the applicant in the application for customs action, it refers only to counterfeit trademarks and pirated goods. The goods must not be perishable goods. As I said, the small consignment procedure must be requested by the applicant in the granted application for customs action. And this simplified procedure only applies to small consignments of 3 units or less, or 2 kilos or less of gross weight. And how do we act with regard to these small consignments? Notification by customs takes place only to the declarant or the holder of the goods of the detention and the intention to destroy the goods. So already in the application for customs action, the right holder requests the small consignment procedure. They agree to the destruction. They give sufficient information for customs to establish if the goods are counterfeit or pirated goods. And only the declarant or the holder of the goods are notified. If the declarant or the holder of the goods agrees within 10 working days of the notification, or if the deemed agreement is applied, customs proceed to destroy the goods. And now I will proceed to some IT aspects of the customs procedure. So we encourage our partners to have in place electronic systems for the management by customs authorities of applications for customs action. In the EU, like I said, since October 2024, the lodging and management of applications for customs actions is fully electronic. These applications are then sent and stored into the central EU database, which is called COPIS, Anti-Counterfeiting and Anti-Piracy Information System. And so the management and the processing of AFA from 27 member states is centralized there. And also, based on Regulation 608, customs administrations of 27 EU member states are obliged to report the detentions in this IT system. And this is important to have an overview of the scale of IPR infringements in the whole territory of the EU, and also to have a whole overview of all the applications for customs actions, whether they are national applications or EU-wide applications for actions. Because if we have an EU-wide intellectual property right, such as an EU trademark or EU design, the AFA will cover all 27 EU member states. And so thanks to this electronic flow of information and exchange of information, we are able to annually have this publication, which also Berenger was referring to earlier this morning. So every year, EUIPO, together with the European Commission, publish this report, which covers both the results at the EU border and in the EU internal market. And it gathers, with regard to customs detentions of IPR infringing goods, data from all 27 EU member states on an obligatory basis. On the other hand, with regard to the detentions at EU internal market, the relevant national authorities report their data on a voluntary basis in EUIPO, and this, let's say, complements the whole picture of IPR infringements in the EU. The objective of this publication is to provide useful information to analyze IPR infringements and to develop appropriate countermeasures, and to provide EU policymakers with data to develop priorities and policies to fight IPR infringements. And with this, I thank you for your attention, and I'm sharing the website of TAXUD and the page related to counterfeiting, anti-counterfeiting, anti-piracy measures. And I thank you for your attention, and I will welcome any questions what you might have. Please don't hesitate to ask either right now at the end of the session or in the afternoon. From the side of TAXUD, we stand ready to provide you with any additional explanations as to the EU legislation on customs enforcement of intellectual property rights. Thank you so much.